My name is Michael Friedewald. I'm from Fraunhofer ISI in Germany, and I will have the pleasure to moderate this panel. And I will not waste a lot of time with an introduction because we do not have an umbrella theme or something like that. Maybe consent is something that all the presentation have in common. Anyways, I don't want to waste any more time. And I would like to introduce Katherine Nolan from LSE in London, and she will present us her paper. You already see the title, The Role of the Individual in Data Protection Law. Katherine, please, the floor is yours.
Thank you so much. Hello, everyone. Thank you for your attention today. As Michael said, my name is Katherine Nolan. I'm a current PhD researcher at the LSE. And so this paper that I'm presenting today derives from my broader PhD project, but today I'm particularly focusing on this topic, which is the role of the individual in EU data protection law, object, subject, and agent. So initially, let me outline what I'll be talking about in this next short 10 minutes. The research question that I'm thinking about in this paper is, what is the role of the individual under the General Data Protection Regulation and Article 8 of the EU Charter? And so this paper examines the role of the individual in EU data protection law and suggests that both the individual is central to this regime, but that the individual's role is multifaceted. Why might we be interested in this? Well, even over the past few days, there's been a number of interesting panels and discussions around this idea that data protection law is individualist, or that we should be moving to alternatives. We should be thinking about collective, group, relational approaches. And so all of these concerns that we've been discussing over the past few days, well, they reflect a discussion that we're seeing, of course, in the literature. And so this suggests that we have this concern about the individual or individualist approaches that come from a range of different perspectives. But to date, we don't have this kind of comprehensive elucidation of, well, what is the individual doing within data protection law? And once we have such a model, I hope that we're able to evaluate these claims about individualism within data protection law. And so I suggest that it can be helpful to have a more precise conceptual model of what the individual is doing within the data protection regime, and we can therefore be more precise about assessing the capacity of EU data protection law to meet its stated goals. And so in this presentation, I'm offering you my conceptual framework of the individual, that of the individual as object, subject, and an agent. And so this formulation, these are terms we're familiar with. A number of scholars have used such terms in kind of parallel fields of scholarship. And I'll spend the rest of the presentation kind of explaining what I mean by this and how I see it operating through the regime. So to begin with, how is the individual an object of data protection law? Well, of course, the protection of the individual and that individual's fundamental rights serves as our normative foundation for data protection law, as well as the primary law competence justifying the adoption of much data protection legislation. When I say the individual is a subject of data protection law, by this I'm referring to the subject of protection. Of course, we know our category of the data subject. And then sometimes also we might have third-party natural persons, individuals who are being protected under the regime. When I refer to the individual as an agent of data protection law, well, in this case, I'm referring to the fact that through the protection of individual decision-making and the grant of individual procedural rights, well, the individual is one of the actors through which data protection is realized. So having introduced this array of terms to you, I'm now going to delve into each in a little bit more detail to explain what I mean. So first, I will turn to this idea of the individual as the object of data protection. And hasn't gone on. So the individual status as the object of EU data protection arises because, as I've said, this protection of the individual serves as our normative foundation for the data protection regime. Of course, we've seen transition over time. We know that the Data Protection Directive was initially adopted with two primary objectives, that of the free movement of data throughout the EU, as well as this idea of a high level of protection for individuals. And over time, we've seen transition, particularly post-Lisbon, to a more protective model as Orlolinsky has observed amongst others, that we've got this transition from market harmonization towards a more fundamental rights orientation. And so this status has legal significance, we can say, in at least two important ways. The first is that our primary law competence to adopt EU legislation is linked to individual protection. We know that while the Data Protection Directive was adopted as a market harmonization measure, the GDPR is adopted on the basis of Article 16 TFEU, which is expressly linked to the protection of individuals. And the second way in which we can say that this kind of normative role of the individual has importance within the regime is by reference to the court's interpretive approach. So we know the court tends to take this teleological or purposive approach, which is informed by the desire to achieve complete and effective protection of individuals, and that this has had quite a transformative effect on some of the interpretation of threshold concepts of data protection, things like our material scope concepts or geographic scope, for example. So if we move then, if I can find my page, to the question of the individual as the subject. Now, I should mention a caveat. Of course, the individual can also be a responsible subject. They can be a data controller or a data processor. For reasons of scope, I'm excluding that discussion from my short presentation today, but I'd certainly be happy to talk about it in the questions. And instead, I'm looking to this notion that the individual is our protected subject, our data subject, within the regime. And as the protected subject, of course, the logic of the GDPR is shaped by this notion of an individually protected subject. And we see this, for example, through the definition of the scope of the GDPR, which of course comes from this concept of personal data, which is defined in terms of our identified or identifiable individual. And secondly, when it comes to our assessment of the legality of data processing, this is often also defined in terms of the individual. We see this probably most clearly within the legal bases to processing. We know that consent, an individual's contractual choices, an individual's vital interests are all expressly linked to the individual. And an individual's interest is also part of the weighing and measuring that takes place when it comes to legitimate interests or processing which is justified on the basis of legislation, public legislation. So, yes. So then when it comes to the protection of the role of the individual as an agent, of course, I'm not saying that the individual is the only agent of data protection law. We can point to our accountable data controllers, judicial authorities, DPAs, etc. Nevertheless, we can see that the individual has an important role to play in enacting or the completion of the data protection project. And thus we can consider this in kind of a proactive or a reactive sense. In the legitimation of individual decision-making, we see that the individual gets to proactively determine how their data may be processed. In such an individual's consent or their decision to enter into a contract is given this legal imprimatur, which is then protected by the regime. On the other hand, where an individual has suffered some kind of illegality or they're unhappy with the manner in which their data has been processed, they have a series of procedural rights that they can exercise either against data controllers through the suite of data rights, or they can have recourse to remedial rights through complaints to DPAs, etc., or to the courts. And so in this way, it's often an individual's action which will bring the notice of wrongdoing before a court or before a DPA. So if we take all of these roles together, I hope this offers a kind of comprehensive, or certainly a more comprehensive conceptual way of thinking about the different ways in which the individual is central to the data protection project. What does this offer us in terms of contribution? Well, I hope that we can see that the individual, of course, is central to the regime, but their role is multifaceted. And so in looking to the separate ways in which the individual operates, we can have perhaps a more precise critique of some of these. So rather than thinking about individualism in the abstract, we're empowered to question more deeply or to interrogate more deeply some of these questions. And so perhaps I'll leave you with some questions that my framework might suggest and we could bring into questions later, which is, well, if we recognize that the individual is an object of data protection, is this too narrow? Do we need to be thinking more broadly about group protection or structural protection? Or what is the value of having our discussion centered around individuals? Is the focus on the individual subject under-inclusive or misdirected? Are there other conceptions of either persons or groups that have been underserved by this legislation? Is it appropriate to expect individuals to defend themselves as agents of data protection law? Do we need to be doing more to create an environment in which such rights are realizable? And so I hope these questions offer us a basis to think about individualism and the centrality of the individual within the regime. And I will finish up there. Thank you very much.
Thank you. Yeah, Katherine mentioned already that it is raising questions, so the floor is open for more of them. Gloria?
Hello, everybody. Good morning. And thank you very much. I think it's very, very nice to have this object-subject agent. I have a question about the theoretical normative foundation of the individual being there. And maybe I believe this for a while, but I'm more and more doubting that this is true. And I think my German is very bad, but when I try to read German authors, I think for many German authors, this idea that the individual is the key is wrong. And especially in the 70s, many of them were inspired by Luhmann and this idea that it's about a system. The individual does not exist. The individual is an accident. There is only one system, and it's about data processing. And so are you considering these theories, integrating this somehow? And then how do you manage? Because there is really the opposite idea that the individual is not the key of anything. Thank you.
Thank you. So is my paper completely wrong? No, it's certainly, no, it's a valuable provocation. I think in some ways my paper and my theorization, I didn't talk about my methodology, but it was constructed on the basis of a kind of thematic analysis of the legislation and the court's decision-making in this way. And so it's intended to be driven by the role in which the individual is having legally, but I think that might pose an interesting contrast that I haven't particularly considered, but I'll certainly take away because I think it could be a valuable kind of counterpoint to the notion that we think the individual ought to be having, and then the kind of legal or operational impact that we're seeing the individual having. But thank you very much, Gloria.
Thanks a lot for the presentation and the paper. It's fascinating. I also agree with you. Many questions can be asked based on this framework. But I was also wondering what could be potential negative consequences, because as soon as you start to perceive individual as potentially separated aspects or, I don't know, identities, then that might be also misused. Because someone can say that, oh no, actually here I'm talking about individual as an object, and then there is no subject anymore, or there is no agency anymore. You know, I like the idea of separating, but in the same time, it might be misused. I don't know. How do you reflect on the potential negative aspects of this?
Thank you very much. I suppose I should say that I'm not trying to present a normative paper, that this is my understanding of kind of how it's operating analytically. And I hope that in offering that we can problematize it, so that I hope it doesn't have the effect that you suggest, that it crystallizes a notion of what the individual can be, or that we should only think of individuated persons rather than, other conceptions of personhood, which I think, there's been lots of valuable contributions to, even over just the past few days, and how we think of personhood and how it's reflected in the law. And I also think perhaps that I've separated into these categories, but I don't want to suggest that they are completely unrelated. The idea that we would have an individual subject informed by an objective or by a normative desire to protect individuals is perhaps a kind of conventional regulatory approach, that we protect individuals qua individual. But I don't think that we should be constrained to that convention. And I think a lot of the interesting work that's been coming out about how do we improve data protection law, or how do we complement existing approaches, suggests that we should look beyond those conventions. And so thank you very much, because I think your question prompted me to articulate that a little more clearly.
Hello, thank you for presentation. I have just another follow-up question regarding this. Always, as also like the general concept, we always consider data subject as vulnerables and we should protect. But I think your analytic framework provides further insight, like data subjects are also agents. And let's assume that like these individuals are fully capable and they are all happy with what is going to do to themselves. In that occasion, there will be some conflict of the data individual as a subject and individual as an agent. So then the question is, what will be the choice in data protection framework, or in normatively, what will be our approach? Should we protect individuals against their wills, or we should stick? Thank you.
Yes, thank you very much. I think, yes, absolutely, that there is this tension between the idea that we want to empower individuals, or that individuals are inherently empowered, and at the same time, we have protective, paternalistic approaches in circumstances where we believe that they're not capable, or the environment in which they're being asked to exercise or protect their rights are not suitable. I hope that, by articulating the roles separately, by thinking about these separately, we are able to more particularly think about this balance, and what type of conditions are we expecting individuals to be agents within, can help us try and find where is the balance between paternalistic legal standards and creating an environment in which we are empowered to safeguard our own interests. And of course that might vary depending on, we've seen lots of discussion of this vulnerability. Are we all equally able to act as agents, I think, is another important element of this discussion. Thank you very much.
Last question.
Hi, thank you. I think this was very thought-provoking for all of us. A linked question to generally power imbalances, informational asymmetry. Now there's a tendency in academia, a group that suggests all data subjects are vulnerable. We are not in a position to make choices, at least free and informed choices. And this also links to the power imbalances also in the competition law, where now data sharing, for example, in the new legislations are automatically provided, that I don't need to go and ask for it, as opposed to the GDPR data portability, right? What do you think in general that the data protection law should go, because this is your area of research? Do you think we will slowly give up from the individualism on that, or what do you think in general? Yeah.
Yeah, what's the answer to my whole PhD, which I'm
yeah,
hopefully almost there
well, what do you feel?
Yeah.
I know there is no definitive answer.
Yeah. I think, I don't see a complete move against individualism, because there is a value, there is a value in recognizing the uniqueness and difference of all of us. And I think vulnerability as a framework, is a way of thinking of that. That my understanding of this vulnerability literature is not that we are all inherently vulnerability, but the way in which that materializes differs depending on, identity, experience, and the circumstances in which we operate. And therefore, I think we have to think about both what, the GDPR seeks to protect, but also the environment it creates, and to what extent, we are creating notional agency, or we are creating notional paternalism that cannot be realized within the environment which we seek to act. And I think that speaks something to the balance between the individual and the structural or systemic. And if we are in an environment of mass data abuse, can we expect individuals to safeguard themselves against such, environmental threats or structural threats to their data protection? And that it's probably we're going to find some balance between creating the best circumstances in which individuals can empower themselves and protect themselves, and also seeking at a collective or public level to redress some of the kind of mass data abuse that we might be concerned about.
Okay, thank you, Katherine. And we'll move on to Davide Parrilli from the European University in Lisbon. He has done an empirical work on the practices of cookie banners, especially in the media industry, and he will tell us now a little bit about user privacy through ethical design. Davide.
Thank you very much. Thanks to all of you to be here. First of all, good morning, of course. Well, I know that there were quite a lot of presentation about dark patterns and manipulative design in the last few days. First of all, I hope that you are not too tired of hearing about dark patterns. At the same time, I'm also happy because it makes my life a bit easier and I don't have to explain since the beginning, since the foundation, what dark patterns are. So my presentation and my paper is part of a PhD project in design, ethics, and privacy, under supervision of Professor Rodrigo Ramírez, who is also a co-author of the paper. So basically, we did a field research about dark patterns in cookie banners in the media landscape in Europe. And the methodology we adopted is basically we assess 80 websites of media-related field from 8 countries, being Belgium, France, Germany, Italy, Portugal, Spain, Netherlands, and the UK. Well, first of all, very briefly, as I said, I don't have to explain, but in case somebody just pop up at the conference today, with dark patterns we mean design tools to nudge or push or whatever, everybody can choose the verb they prefers, users to do something that otherwise it will not do. And in case of privacy, when we talk about dark patterns in privacy, means tools, design tools to push or invite or nudge users to provide more data that otherwise they will be willing to do. Why we selected these countries? Well, not only for the relevance, but also from very practical reasons. I mean, these are countries where the research team either speak the language fluently or can easily understand what was written in the cookie banner. I mean, just to tell you that the research was not based on third-party information, but was really a field research done 100% by the research team. And well, during my presentation, I mean, I want to entertain you and show some dark patterns that we assessed, we found during our research. Starting from, well, the country where we are, Belgium. And here is a cookie banner of Rolata Media Group, I mean, powerhouse, a media powerhouse in Belgium. And here there are 3 dark patterns, but I show you 2, and then the third one is linked to the next slide. The first one is, well, it's impossible for users to immediately reject cookies. Either they can accept all cookies or they can learn more about that, but there's no button to say, no, I don't want any cookie. I refuse all of them, I reject all of them immediately. And the other dark pattern we identified is that the option to accept all cookies is graphically prominent. I mean, it's for a number of psychological and design reasons, users are prone to click on yes, accept cookies for design mechanisms based on the kind of color and the structure of the button that has been adopted. And there's also a third dark pattern, which is related to this slide. Either in the case of Rolata, I mean, Rolata is a Belgian media group, and even if in Belgium English is widely spoken, it's not an official language. So why a media group that publishes mainly in Dutch and also in French, why that should have a cookie consent banner in English? And the same here, an example from Spain, from ABC, a website is entirely in Spanish, but the cookie consent banner, which is in English. And here apart from the two dark patterns that we identified above, so it's impossible to reject all cookies immediately, and the bottom agree is graphically more prominent. We also have the third dark pattern being the cookie consent banner entirely in English, and why it's not in Spanish. You have an example from our country, Portugal. This is an example from Público, a very respected Portuguese newspaper, but it's a dark pattern that is we found across all Portuguese media that we assessed. Not only in Portugal, but Portugal meaning pop up to our attention because all 10 websites had this kind of dark pattern. Being that users must give the consent to accept, for cookies based on legitimate interest. So the cookies based on legitimate interest, they are, the default setting is that users accept them. And if they don't want it, users have to opt out by clicking Rejeitar tudo, which means reject all. Which is, there are, I guess, a lot of lawyers in this room, and they can teach that much better than me, but it's illegal based on also on recent court cases of the European Court of Justice. So users, when, in order to have cookies based on legitimate interest on their device, they have to accept. Please, if I'm wrong in our interpretation, tell us. Tell me, because I represent the group. Here we have example from Germany, which maybe is the most worrying example that we found. Is a dark pattern, or cookie paywalls, as it's technically named, that we found out in website in Germany. We also made like a side research in other German-speaking countries, such as Austria, which is not part of, the main research, but we found out this kind of cookie paywalls also in the Austrian media landscape. And basically, cookie paywalls means that people, if they don't want to be tracked, they have to pay. So newspapers and media companies monetize the willing of users not to be tracked and monitored through through cookies. And just to come up to the research results. So out of 80, here we assess 80 websites, and we categorize in three groups. The green one is a website with no dark patterns, or websites that do not process personal data. The yellow category is when the cookie consent banner has two dark patterns, up to two dark patterns, and the red one when there are 3 or more dark patterns. As you can see, the vast majority of cookie consent banners is labeled red. So that means that out of 80 cookie banners, I give you some details, only one website is free from dark patterns, which is from Germany, the website of ad.de, so the public broadcaster. Only 2 media declare that personal data collected through cookies are anonymized, and both also from Germany, ad and Deutschland Radio.de. We have some examples from the Netherlands where the public broadcaster, for instance, declares that the data are anonymized, but then, or they even declare that no personal data are collected through cookies, but then when you go to read the policies and the documents annexed on the website, you realize that the reality is completely different. And even, for instance, that they said that we are not going to process any personal data, but actually they do, and they also install marketing cookies and advertisement cookies on the user's devices. So, reality is sometimes different from what is advertised or communicated by the media companies. Here you can see, the 9 group of dark patterns that we identified. This is also the other part of the categorization effort of the research team. And based on the 9 categories, there are 3 that are predominant, being the lack of unequivocal and immediate possibility for users to reject cookies, 68 websites out of 80s. The second one, the different fonts of colors for the options, 64. And the third one, the pre-selected option to accept some cookies, as we saw in the example of Público from Portugal. And based on countries, well, we saw that we don't have any let's say, country that pop-ups as a good example. We have some worse example, we have some better example. Maybe we can say that France is a slightly better example because there's 9 websites on the yellow group and only 1 in the red label. Portugal, for instance, unfortunately, is maybe apparently the worst one because it's, all websites are in the red category. We also have to, I mean, there's something that we point out in the paper that, of course, not all dark patterns have the same level of gravity, let's say, are not as bad as others. So, for instance, in the case of Portugal, we saw that the case of legitimate interest, and people have to concentrate on that. But, for instance, Germany has the paywall that Portugal doesn't have. Which is worse between the two? Well, that's open to discussion. And unfortunately, in 10 minutes, we cannot have this discussion. Jumping to the conclusion. Conclusion and questions that we have. The first one is regulation the only answer to address the topic of dark patterns in the design field? The other conclusion that we reach is that maybe is the right time to discuss about legitimate interest. Do we have it or do we need it or not? I mean, I don't have the answer now. This will be for another conference, but this is a question that we think is useful and interesting to think about. We also realize that there is an asymmetry between the interest of users, I mean the interest of privacy of the user, I'm not talking about privacy rights, I'm talking about privacy interests, and the interest of the company. I mean, users may not have very well defined in their minds the interest to have their privacy protected, while companies have very well clear in their mind the interest to make money out of users' information. So there is this asymmetry of interest between companies and users. The main conclusion that we reach is, well, unethical design created dark patterns. I mean, we're talking about design issues. And we strongly believe that ethics in design has to carry solutions and at least proposals to fix the problems. And finally, the design ethics is much more than legal compliance and privacy by design. Although in the word privacy by design, there is design inside. Well, design ethics is much more than that. And just, just to be, just to conclude in a designerly way, so not only about theories, but also about practice, I want to show you some, an existing example of partially ethically designed cookie banner, where here you see that people can reject all cookies since, let's say, the beginning of the navigation on the website, but still there is a dark pattern because, I mean, no thanks is less visible, let's say, in non-technical words, then it's okay, I want to have dark patterns. So using methodology of speculative design, we created roughly our own ethical cookie banner. And basically, what we like to do is like make ethical dark patterns. So take exactly the same habit of having dark patterns, but redesign them completely and make them ethical. So in this example that we create, I mean, it's not commercially existing, it's just the result of our imagination. You see that people have only one option, so it's the dark pattern. They can only reject all cookies. They cannot have the cookies installed on their device. And then, of course, if they want, they can manage the preferences and add the cookies they want to have installed. So basically, sometimes, well, we don't have to reinvent the wheel, just take the bad habits and make them a bit better. Thank you very much for your attention.
Thank you, Davide. I have many questions. I see that the public also. Let's start with that.
Hi, I'm Portuguese and I also work on this domain, so I think we would like to exchange maybe later.
Sure.
I have some questions for you. The websites regarding news, they have all the same parameters because they just embed the same CMP. So maybe I would like to ask you, what about checking these dark patterns, but at CMP level?
Yeah, we basically it's a very good question. It's a very good point. What we did is, I mean, our approach was not based on on the industry, but was based on the users. I mean, for me as user, it doesn't matter who designed the website or I mean, who is the provider of the cookie banner. For me as user, what counts is, well, I have access to a website, I want to get news, I want to have entertainment, because media companies are also doing a lot of entertainment. So from my point of view, from the user point of view, it doesn't really matter. I mean, these technicalities.
Well, it matters because they will always be the same. The dark patterns that you will identify will actually be the same whenever the CMP is embedded.
Yeah, for the case of Portugal, it's true. But for other countries, it's partially true. Because, for instance, if we go back, let's see if I can't go back. In other countries, it's more nuanced. So there are like group of companies, for instance, group of media from the same company that have the same CMP, but other groups who use completely different CMPs.
I see. No, yes, indeed, it varies by CMP. Regarding paywalls, why you think they are dark patterns per se? Because they are very different business models, and it only becomes a potential dark pattern when there is a ad tracking free possibility that you pay with data or with money, but then you are still tracked. So only when that possibility happens, then that might entail a dark pattern. And the third observation.
Maybe we give the chance for others to ask questions. Thank you very much.
We can discuss later if you want.
I think, Frank and then.
Maybe that's not that kind of problem because I'm totally in line with my colleague. So yes, there might be certain groups showing the same set of patterns or so, but I would be quite confident that all those websites will again use the same technical framework for producing it, and therefore, so why don't you just add that additional level of analysis to your research of this website uses that framework and we have this and that finding. And then you might group them and see, all those groups or all those websites in one group actually use that framework and the others in that group use that framework, and therefore we can say something about, framework A has way more dark patterns or so. So why don't you have such an additional? Why don't you think about adding such an additional layer of analysis? I think that would be a great benefit. First question. Second question. One very brief. Regarding the different languages, what were your language settings in your browser when you did that?
Well, to answer the second question, we tried with different computers. And the result was the same. So one was the setting was in English, another was in Portuguese, another was even in Italian. So and the result was exactly the same. We also used different browsers, different devices, and the result tended to be the same. To answer your the first question, there are a lot of other ways to make the research. I mean, we had to make choices, and we made a choice. We could take, there's not the only, there are several ways to carry on the research. But actually, the main justification and also the main macro result is that it shows that dark patterns are really a design problem. It's not only, as you said, it's not per se a problem. You may agree or disagree, but yeah, this is our research. This is the result of our research. We don't want to sell the truth. We just sell opinions. It's a design problem. It's not a matter or mainly a problem of legal compliance by the media company, but it's really more a problem of how things are designed by designers.
So I see there is obviously a lot to discuss, and you will be here probably after the session. So we unfortunately have to move to that position because we have to move on to the next paper. And I'd like to give, thank you, Davide. And I'd like to give the floor to Maximilian Hiltz from Innsbruck University, who has done also some empirical work on a similar thing and to some extent something completely different. And I'm looking forward to your presentation on the privacy signals from the various attempts to avoid being tracked.
Thank you very much. Is this on? Yes, okay, thank you very much. So I will preempt this by saying no dark patterns in this talk. Yes, I'm Max Hils. I'm a PhD student at the University of Innsbruck in Austria. You can see our beautiful mountains up here on the slide. What sets me apart from most of you is I'm a computer scientist. Like, my law background is very, very shaky. So what I will talk about will mostly be non-law stuff. But now that I have this unique opportunity to talk to lawyers, I thought, why talk about my paper? I'd rather plug old work. So my PhD very much is about the consent ecosystem. We started measuring shortly before GDPR and did millions of websites visits per day and looked over 3 years how various CMPs were adopted on the market. We can see a few things, like obviously mid-2018, like exactly 4 years ago, GDPR hit, and then shortly after we see all the websites adopting CMPs. Down here we have CCPA, so there we track the US, which is interesting. Some companies very much are affected or see a significant uptick, others not so much. If you look at, for example, the first large GDPR fine from CNIL, websites didn't care that much. Not much of an influence on the adoption of CMPs. Yeah, so this paper was at the Internet Measurement Conference. I know this is nothing that lawyers read regularly, but if you want to check it out, here's the short URL or there's the QR code. Similar work we did last year was on the history of privacy preference signals. So we see TCF as the current framework under GDPR, but there's actually quite a bit of history to that. We have P3P going back to 1997. Again, I will leave out all the details. If you want to look at how this worked back then, again, same URL, same QR code. For now, what I want to focus on is this part here at the very left, the very, very current future. Consent dialogues and conflicts in consent signals. So you may ask, how can we have conflicts in those signals? I don't have to explain the very basics to you. Here we have a consent dialogue, and if I, as a user, because of dark patterns or whatnot, click yes, what happens on the technical layer, so this is the non-lawyer part, that this will set a cookie, and that cookie is transmitted with each HTTP request that I then do to those websites. So on the UI, we click here on the website, and then on the HTTP layer, we have this as part of every request. Now, you all know all those dialogues super painful, and some smart people proposed alternatives. Namely, I will summarize that as global cookie settings. So there are ADPC, which is more targeted towards the GDPR, and then there's the global privacy control, which is basically the successor of Do Not Track, but mostly targeted at California. And the way those standards work is that they are not part of the website, they are part of your browser, or they are a browser extension. And within that browser extension, or within the browser, you then configure your device to also send a global opt-out request. And interestingly, on a technical level, that happens exactly on the same layer. So we have this one HTTP header, which is the cookie, which says, oh, I give consent to being tracked. And right below that, or above that, we have the next header from this browser extension, which says, oh, please do not sell my data, please do not track me. And yeah, what do we do now? From a practical point of view, I think there are two questions. The first one is this an actual problem, or is this something academics ramble about, but actually never happens? And the second part is then, once we have cleared that up, which signal should actually take precedence? In this paper, sorry to disappoint you, we really only looked at the first part. I will be very quick here, just to give you an overview. We have about 60,000 page view impressions, which is not too much, but good enough to show our effects here. In a lot of cases, we see browsers blocking dialogues due to ad blockers. Then we have users where GDPR does not apply, where we don't show dialogues. Then some users repeat visits, so they have existing cookies, we don't need to show dialogues. But then we have about, give or take, 2,000 cookie dialogues that are shown, and where we then observe the user's choice. But at the same time, we also observe if they have a GPC header set or if they have a do not track header set. I will preface this that ADPC would work as well, but when we did this study, really GPC and do not track were the only adopted solutions at this time, so I will here focus on GPC, but you can apply it equally to ADPC. And yeah, just very short, we do see here we have about 500 something users which do send a GPC header. For those users, you can see actually a very large fraction, that's the yellow part here, which block the cookie dialog entirely. So no matter which CMP or for this specific CMP, you don't see a dialog anyways. But of those users who do not block GPC, we still see a large fraction of users who accept tracking. And this green bar down here, this is basically the part where we have conflicts. And yes, the sample here is small, but if you extrapolate that to larger websites, then you see this is a problem that appears in practice. Okay, so does this happen? Yes, it is something we should talk about. And now the second part is which signal should actually take precedence. Yeah, I mean, if you talk to privacy advocates, they will all tell you, well, this GP3 thingy here, sure, no tracking. But I don't know if we have anyone from the IAB here. I guess not. But if we would have someone from the IAB here, they would probably say, oh, look, like this browser setting you configured once, maybe for this specific website you have different preferences. So for each website we can show you a new dialog. And if you say yes in that dialog, that arguably is more specific, that is a more informed choice for this specific website. So really, from our IAB perspective, we think this TCF signal should take precedence. From a privacy advocate's perspective, that is kind of painful because you try to solve this cookie banner spam, and all they do is say, yeah, but this is more specific. We still show the dialog, and whatever the dialog says should be taken for account. So, yeah, I think there's maybe a good point. Again, I'm not a lawyer. There's a good point to say, look, consent needs to be unambiguous, and surely there's some ambiguity here. But this ambiguity already exists in practice, and so far they just ignore the bottom part. So maybe that's something that should change. Yeah, let's sum this up quickly. In this paper here, we just provide first evidence that conflicting signals are something that happens in practice. The policy conclusion from my side is that for ADPC or GPC to be successful, the regulators need to push that those signals have like more influence than site-specific signals such as TCF. Otherwise, this will not help resolve this consent dialog spam. And yes, final part, shameless plug again. If you are looking for more tech-related research on the TCF ecosystem, here again is the QR code. Thank you very much.
Thank you, Maximilian, for being short and to the point, and this leaves us room for discussion, and I already saw some hands.
Thanks a lot, Max, for presentation. Like always, it's fascinating to follow your work. I have a few remarks or concerns about this work. Actually, first of all, GPC, or colleagues from GPC are not here, but I have had many discussions with them. First of all, GPC is implementing do not sell based on Californian law, to the best of my knowledge. And that's not exactly do not track. And then it doesn't necessarily mean that if a GPC signal is there, then other types of tracking using cookies should not occur. Then it means that it's, first of all, there might not be a conflict because maybe the meaning of these signals are different. That's the first point. The second point is that GPC is functioning based on Californian law, and it is not clear what does it mean based on the GDPR, because based on the GDPR you do not have any notion of do not sell, which means you receive a binary signal as a data controller. I would say, again, it is my personal interpretation, I would say if you want to consider GPC, that would not be a very lawful act. It's because, according to GDPR, we have no idea what GPC might mean. There might be an interpretation soon, at some point. I'm not saying that there never be an interpretation, but currently it's very ambiguous in Europe. What does it mean if I have received a GPC signal as a data controller? Then the other thing that is very important to consider is that GPC signal is an opt-out signal, which means that in the best case, and again, not opt-out for everything, just for selling, that's it. Not all of it. It's not saying that do not collect, do not whatever. It's just do not sell. And then still, if you use GPC, other types of consents are needed based on GDPR, and it means GPC, based on the current implementation, never will replace cookie banners. Then it means that we will always have that. But then the final remark that I have, and I'm so sorry that it took longer than maybe your presentation, is that ADPC is very different. ADPC can send opt-out signals, very diverse one, from really cleaning the disk and say that I am opting out from everything, to very specific ones similar to GPC. Do not sell, do not track, whatever else. But also, ADPC, what provides is opt-in possibility. That can actually replace the consent banners and what they are providing. Again, then I'm sure what you're working on will happen soon, even if we have fully implemented ADPC communications, then still we have to answer this. I'm just thinking that you're super intelligent and super fast in doing your research. Maybe we have to repeat what you did in 1 year and 2 years again, you know what I mean? Because I think it's a little soon. We are really not sure if this is a conflict or not. And I really encourage you to just keep doing it. That's awesome.
Okay. I feel like that was a lot of comment and little question, but I will still address a few points. I know no one from the GPC folks is here, and I think we all agree that ADPC is much more tailored towards the GDPR. GPC is very simple, very straightforward. ADPC has a lot more complexity. That being said, if you look at the GPC spec, they do have an interpretation for the GDPR, and that's maybe something one could look into. I think the problem of conflict between GPC with GDPR interpretation and TCF signals still exists. And yeah, frankly speaking, what we can measure so far is GPC because it's relatively widely adopted. And very pragmatically, I'd rather see a widely adopted, not perfect standard than a not widely adopted standard that has a lot more complexity. I will hope that ADPC eventually will solve this problem, but for now what we can see is GPC, and maybe with a bit of regulatory pushback we can get to a point where GPC is good enough that advertisers stop bothering with dialogues in the sense of, okay, there's ambiguity anyways, we don't get the consent we really want anyways, we can do whatever we need to do, maybe based on legitimate interests. I'm not a lawyer, again, but I think that we will see. The thing is we will have conflicts and we need regulators to make sure that if those conflicts are that the user-friendly signals take precedent over the signals developed by the edtech industry. I think that's the main part.
Second question of that. Hello, thanks for the presentation. Álvaro Feal, so in the networks, fellow computer scientist as well. So my question, I think, is a bit probably more towards the future, but anyways, you were saying that you plan to try to understand when there's a collision such as this, what is honored. But in the past, we've seen that things just do not track, and even cookie consent banners are just not honored at all. So even if you say yes, you're going to still be tracked. So do you envision that might make it hard to actually measure what is going on in reality? Because it might be just that both of them are being completely disregarded.
Okay, a bunch of answers to your question. I'll try to keep it short. The first one, whatever signal we have soft privacy. We always rely on the recipient to respect the signal, and if the recipient says, oh, well, send me whatever you want, I process anyways. Like, none of that goes in that direction. We are out of enforcement here. We're really looking at this from a compliance point of view. And the second answer to your question is, do not track was happily adopted by browsers because it had no legal binding. With cookie consent banners, that was not so happily adopted, but was needed to get consent. I think once we have a standard that is somewhere anchored in law, then that actually works.
Yeah, thank you, Maximilian, for this.
Thank you.
And then we move on to our fourth panelist, who is hopefully okay. He's online. So after a couple of more technical things, we are moving back to a legal paper. Wenlong Lee is a postdoctoral researcher at the Birmingham Law School, and will, you already see the title, talk about the Uber-Ola judgments. And well, I'm looking forward to your talk, Wenlong.
Thank you. Hello, everyone. I would like to start by saying that this is the weirdest presentation I've ever had. With me, sitting in my room thousands of miles away from Brussels, to a group of people in a room that I cannot see. So it really gives me a sense of panopticon and the frustration that I cannot join my friend Jill. I know she's somewhere in the room, and to meet everyone in person. But anyway, this paper is kind of a spin-off to our research project on worker rights, particularly using GDPR as a leverage. And we originally intended to see the implications of these rights when used, as part of the worker resistance. But when we dig deeper into the cases, we realize how rich and interesting these cases are. So we decided to write a paper exactly about the data rights in these cases. So the cases I just mentioned came from the Amsterdam District Court, and symmetrically, there are 4 of them, with 2 about a group of drivers from the UK and Portugal seeking access to their personal data by exercising both the right of access, the right to data portability, and the Article 22 right, the right not to be subject to automated decision-making. And another 2, which are sometimes called a robo-firing, is about the deactivation of some drivers for committing alleged fraud or something like that. So they either exercise Article 22 or to challenge these automated decisions, or to request access to data, particularly those about the logic of those algorithmic decisions. So I will give a fairly brief and swift overview of these 3 rights, respectively. So the right of access is, as many would say, a cornerstone of EU data protection law. And it was established quite a long time ago, even before or at the time of the rise of internet. So it essentially is about human readability, which means that when we talk about access, it means viewing data on the screen, for instance, or provides you with information that helps you understand the circumstances, or what the data are about and for what purposes. The particular advantage of this right is that it has a broad scope. It, in theory, covers all personal data, and including some, access to the logic or some logic about algorithms. And there are some discussions in the scholarship about collective use of this right, because it can be only triggered by individuals, so it essentially has limited impact. The realities are, as shown by these cases, that whenever the drivers request full access to their personal data, all those requests were consistently dismissed for a range of reasons. And even the purpose of accessing those data to build a data trust, a data commons, that's the original intention of these drivers, with the support of the worker info exchange, were deemed incompatible by the Dutch court with data protection rights. And another short comment, which is not explicitly discussed in these cases, is the lack of machine readability, which means that we may have the information, but it remains contested whether these data can be further processed by or adapted to a new information system. The right to data portability is kind of complements the right of access in that way, and it is, so to speak, the only brand new right introduced in the GDPR, which has no predecessor in the Data Protection Directive 1995. And it was expected as a game changer because it could potentially alter the data production and governance processes. And the right actually has two phases. So it is known as a right to obtain a copy of data and you can use it somewhere else. Or it's also known as a right to drive data flows smoothly and automatically from one system to another. There was some dispute as to whether data portability is really an element of EU data protection law. So there are loads of controversies about it. And if you look at Article 20, you will see loads of provisions, conditions, and exceptions, making the right extremely complex and difficult to operate. Ideally, this right should be enforced if the systems involved are interoperable, which means that data can flow smoothly and immediately from one system to another. But that's not always the reality. And lastly, it is very ideal for building data trust, commons, and crops, because it emphasizes machine readability, reusability, and openness. Reality is the right to data portability has a very limited scope, and there are loads of controversies as to how to define provided by the data subject element of Article 20. And also because it requires machine readability, but there are disputes as to whether PDF is a compliant format, particularly in these cases where the Dutch courts deem it admissible as a way to comply with Article 20 requests. Also, a very contestable aspect of these judgments is that the court refused to support data portability on the ground that the right of access has done the heavy lifting. So you've got your data, so no need to really obtain another copy of it. And lastly, it's not seamless, continuous, and real time, and that's the point where both EU and the UK governments want to address via some other regimes beyond the GDPR. Finally, the right not to be subject to automated decision-making is perhaps the most contested right under the GDPR. It is fairly complex, and that's the reason why the UK government just want to scrape it for good. And it also has two phases. The one is not to be subject to automated decision-making by the name of it. But in reality, it's mostly used as a way to contest algorithmic decision-making and arguably the right to explanation, which is widely discussed in the research community. It is ideal to address information asymmetries, particularly in relation to algorithms, but it is not a proper access mechanism. That's why data trust or data commons are quite useful and needed. And essentially, the reality is, as I said, it's quite difficult to use. And particularly in these cases, there are discussions on whether human involvements are there. And the court just took the word of Uber and Ola saying that they have a human review team without further inspecting the extent and quality of that judgment. And also, this right is quite consequentialist because it is only triggered on the condition that there are legal or significant effects. But this is interpreted quite strictly in labor context because the court would only take income reduction and penalties as significant effects, and others are all excluded. And lastly, I think the plus side of these judgments is that the court, for the first time, recognized a right to profile transparency, which allows the drivers to look at the data that may draw up the risk profile, which can be seen as a real achievement by the drivers. I don't think I have time to really go through, the detailed proposed solutions to these problems, but as you can see, in fact, a fair amount of it can be addressed by guidelines from the EDPB, but there are a few others that are either beyond the GDPR or that it really requires rethinking or legislative reform that I will not detail here. Lastly, I want to give some reflections on the usefulness of data rights overall for worker resistance, because these cases really show some practical hurdles when used in labor context. The first question is, should gig workers or data subjects more generally always bear the burden of proof? This is really a critical matter, as many of the requests were rejected purely on the basis that the drivers are not able to provide evidence, for instance, for the existence of a very precarious database or profile or whatever. And this is an unsettled issue under the GDPR, which means that it is left to the general civil procedural rules. And when I look at the EDPB guidelines, I realize that from time to time, the regulator would touch upon the issue about the burden of proof, but not in an adequate and systematic way. So this raises a very important question as to when should the burden of proof reversed, particularly when there are strong information asymmetries and when those drivers want to exercise these rights exactly for that information or for tackling information asymmetries. Another hurdle is about the purpose blindness of data rights, which means that these rights can only
Could
be
you please
accessed.
come to an end?
Yes, almost there. If it is used to verify the data accuracy or the lawfulness of data processing. And I would argue that this is essentially a historical issue because some jurisprudence, such as the UK, are already deemed irrelevant. And lastly is about balancing rights. although we say that workers have rights to access, but it has to be balanced with user or user rights, for instance. And creatively, the judges provided a rating portability on the condition that those data are anonymized as a condition or as a way to balance. And also, the court rejected the claims by Uber and Ola, saying that this is something destructive to their anti-fraud system. Okay, I think that's there, and I'm looking forward to questions.
Yeah, thank you, Wenlong, for your presentation. We will roughly have 4 minutes or so for questions, so please be brief.
Hi, can you hear me?
Yes, I can.
Okay, perfect. Thank you for the presentation. It would be nice to see you, but this was still nice. A specific question about the nature of Article 22 of the GDPR. I don't know if you're aware of the discussion, but the Greek DPA, for example, perceives it as a right, whereas most of academia and practitioners and DPAs perceives as a prohibition, which has a legal consequence, of course, because if it's a prohibition, first, there is no burden of proof problem. Second, a lot of companies would refrain from using such systems. Did you have a look at this? And what do you think on the nature of Article 22? Because I see that it's very in the center of your research.
We haven't really, look at Article 22 by itself, but only in the context of labor and particularly in these judgments. And in practice, I would barely say that this is a prohibition because the threshold is so prohibitively high for data subjects. If you look at the Uber and Ola, for instance, only in circumstances when the drivers are penalized or have their outcome reduced can they really meet the threshold not to be subject to automated decision making. So I see it rather as a right, in practice for the data subject to contest all these decisions and partially for them to access some information as the cases show.
Okay, thank you. Last question.
Hi, thanks so much, Wenlong. I was wondering, could you explain in a little more detail the specific challenge about data portability? So, like, how did you argue for using the portability right to kind of, did you explain to the court that the idea is to build a separate data platform or data commons / trust? And what was the response then? I mean, yeah, just wondering how that argument went about and why the court decided to side with Uber on that one, on some fronts.
So about the case, I think that the one critical matter appeared or outstanding is that is a relationship between Article 15 and Article 20. And the way I see it, I think clarity is needed when we interpret Article 20, paragraph 4 and Article 15. And I think that's the point where the Dutch courts confused the two rights without really considering machine readability. There's a grave omission of this novel aspect of data portability. That's one thing. And another is even full access to personal data or portable data can be granted. I think it's still limited for the purposes of these drivers to build data trust, because what they need is not just a snippet of information or snapshot of what just happened on that time. What they really need is continuance and smooth access to data. via an API, ideally. I think that's the main shortcoming of data portability right on the GDPR.
Okay, thank you. Thank all the 4 presenters, Katherine, Maximilian, Davide, and Rodrigo. Very interesting talks. I hope you enjoyed it as much as I did, and I wish you a nice lunch.